The Second Amendment, built upon the natural right to life. The foundation, life as the primary natural right. The Second Amendment to the United States Constitution is built on the most basic of all natural rights, the right to life. This principle is that every person has an inherent right to exist and protect their existence, a truth declared self-evident in America's founding document. The Declaration of Independence states, "We hold these truths to be self-evident, that all men are endowed by their Creator with certain unalienable rights, that among these are life." The unalienable right to life necessarily includes the right to self-defense, because a right that cannot be defended is no right at all. The connection between the right to life and the right to self-defense flows logically. Life is a fundamental natural right. Thus, the means to preserve and protect that life must also be a natural right. Otherwise, the primary right becomes useless. As John Locke argued, the right of self-preservation is the first and strongest desire God planted in men. The Second Amendment is a constitutional recognition and protection of the pre-existing natural right to self-defense. The amendment doesn't grant the right to keep and bear arms, but acknowledges and protects an inherent right flowing from the fundamental right to life. The Second Amendment states, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." Shall not be infringed is not a suggestion. It is a command to the government, an acknowledgement that the right to bear arms exists independent of government and cannot be legitimately violated. During the 20th century, a debate arose around the Second Amendment's meaning. Did it protect a group right for citizen militias, or the right of an individual to own weapons? In the 2008 case of District of Columbia v. Heller, Justice Antonin Scalia definitively resolved the debate as follows. "There seems to us no doubt, on the basis of both text and history, that the Second Amendment conferred an individual right to keep and bear arms." In deciding the case, Scalia traced the individual right to bear arms to a natural right that existed before the Constitution, showing that natural law limits and legitimizes government power. Three key legal authorities reflected this understanding. Sir William Blackstone, the English legal scholar whose writings greatly influenced America's founders, described fundamental rights to include the natural right of resistance and self-preservation, and the right of having and using arms for self-preservation and defense. Justice James Wilson, who signed both the Declaration of Independence and the Constitution, taught that constitutional arms-bearing provisions protect the natural right of defense of one's person or house, or the law of self-preservation. St. George Tucker, a Virginia judge and legal scholar, wrote in 1803 that, "This may be considered as the true Palladium of liberty. The right to self-defense is the first law of nature." Tucker's commentary explicitly connected the Second Amendment to natural law principles. Justice Scalia relied on Blackstone, Wilson, and Tucker, and more to establish the original public understanding of the right to bear arms, or how the words were understood in 1791 by those who drafted and ratified the Second Amendment. From 1791 until the 2008 Heller decision, the Supreme Court heard remarkably few Second Amendment cases. This stands in contrast to extensive litigation surrounding other constitutional rights. For over 2 centuries, Americans, lawyers, and government operated under a shared understanding that the Second Amendment protected individual rights to keep and bear arms. For most of American history, federal and state governments imposed minimal regulations on firearms ownership. Thus, there was little reason for Second Amendment lawsuits. The landscape began changing in the 20th century as groups began promoting increased firearm regulations and governments began responding with more restrictive laws. It is worth noting, the Second Amendment didn't change, nor was the Constitution amended. This shift created conditions requiring Supreme Court intervention to clarify what had been previously understood through shared cultural and legal tradition. When the Supreme Court finally addressed the core Second Amendment question in Heller, it validated the 200-plus-year-old original consensus. The court clearly stated that the Second Amendment protects a fundamental right grounded in the right to self-defense. The historical evidence the court provided included Blackstone, Wilson, Tucker, and 19th century state court decisions to show consistency in the original Second Amendment understanding that it protects individual natural rights. The Heller opinion made 4 references to the Declaration of Independence and recognized the natural law foundation of American government with the following quote: "When in the course of human events, it becomes necessary for one people to assume among the powers of the earth the separate and equal station to which the wound laws of nature and of nature's God entitle them." The Second Amendment addresses both individual and collective dimensions of the rights to life, self-defense, and to bear arms. At the individual level, it protects the means by which citizens can defend themselves, their families, and their property, the practical mechanism for exercising the right to self-defense. At the collective level, through the well-regulated Militia Clause, it recognizes the people's right to defend their community and resist tyranny, protecting the collective right to life and liberty of the political community. The 2008 Heller case involved the District of Columbia. The district has a unique place in American law, as directly controlled by Congress. The Supreme Court still needed to affirm that Second Amendment protections applied to state laws as well. In the 2010 case of McDonald v. Chicago, Illinois, the Supreme Court affirmed that the Second Amendment applied to state and local governments through the 14th Amendment. This extended the constitutional protection of the natural right to self-defense to all levels of government. Recognition that the Second Amendment acknowledges a fundamental natural right does not resolve all policy questions. All natural rights, including those in the First Amendment, are subject to reasonable limits. However, when a right is among the fundamental natural rights, government faces a high burden to justify any limitation. The right to self-defense, while derived from the right to life, carries inherent limitations. It must be proportional to the threat, and cease when the threat ends. These constraints reflect the equal right to life possessed by all persons. The Second Amendment stands as a constitutional protection of the natural right of self-defense, which flows directly from the fundamental right to life. The founders, drawing upon centuries of natural law tradition, understood that the right to preserve one's life must include the practical means to do so. This understanding, that the right to keep and bear arms serves as the guardian of the right to life, provides the foundation for interpreting the Second Amendment as an individual right that existed before government and cannot be legitimately violated. As St. George Tucker observed, this right serves as the true Palladium of liberty, protecting not only individual life, but the very possibility of free government itself. The constitutional framework established by the Second Amendment preserves this natural right foundation, while providing a practical, legal structure for its exercise within an ordered society, balancing the individual right to effective self-defense with the collective need for security and public order. Want to learn more about the rights that protect your freedom? Subscribe to this channel, and take a moment to like this video.